Hello and welcome. Thank you for taking time to review this overview of drainage system redetermination of benefits and damages. My name is Chad Martini, and I work out of the Division of Property Services at Stearns County. One of my roles working for the county is to assist the county commissioners in administering all the county drainage systems. The reason this presentation is important to you as a property owner is that any redetermination of benefits and damages project is going to update ditch records to reflect current conditions as it relates to property that contributes water to the ditch. The number of property owners who participate in the ditch system is likely going to increase as a result of a redetermination project. A valid petition from property owners requires by law that Stearns County Board of Commissioners, who act as the County Ditch 28 Drainage Authority, appoint viewers and complete a redetermination of benefits and damages proceeding. Before I get into the questions that I'm sure you have at this point about what redetermination means to you as a property owner, it is important that we understand all costs related to a redetermination of benefits and damages project, including the need to legally acquire a 16.5-foot vegetative buffer on each side of the ditch, will ultimately be assessed back to whatever the final list of property owners who are determined to be benefited by the drainage system in the form of special tax assessments. The goal of this presentation is to educate you as property owners about how the drainage system redetermination of benefits and damage process works. I'll attempt to explain why a redetermination project is happening and how property owners may be affected by the proceeding. It's important to note that not everybody watching this video recording might actually be affected by the project. So what is a legal drainage system? All legal drainage systems are established by property owner petition. Stearns County cannot create a drainage system. That has to happen from property owners. Most of them are very old, from the early 1900s, and the purpose was really nothing more than to drain land for agricultural purposes, although in 2022 we understand that there's a variety of different purposes for drainage ditches. People have found a lot of different ways and benefits from moving water. Once established, viewers determined which properties directly or indirectly benefited from the drainage system. A direct benefit might be the water channel goes right through your property. An indirect benefit might be you're a mile away on a hill and you're sending your water downhill to the ditch. Again, all costs for maintaining a drainage system are paid by those property owners who have been determined to participate in that drainage system, and that payment happens in the form of special tax assessments. So here we have an overview of Stearns County, and we're showing where Stearns County Ditch 28 lies. It runs for about 8 miles, begins in Albany Township, flows north to Holdingford, where it ends at County Road 17. This particular ditch was established in 1906 by property owner petition. And again, the Stearns County Board of Commissioners, who act as the County Ditch 28 Drainage Authority, have that legal responsibility to inspect and maintain the ditch when necessary for the best interest of affected property owners or when petitioned for repair or other conditions. So here we see in the shaded area the lands that are currently benefited by County Ditch 28 as a product of that 1906 determination and viewer analysis. And it's these properties that are responsible for all costs incurred by County Ditch 28. It's important as a property owner that you understand the costs for the ditch aren't split equally across all properties. It's based on the determination that the viewers made of how each individual property either benefited or contributed water to the ditch system. Now, examples of costs that CD28 might generate could be the removal of beaver dams, it could be the removal of downed trees, cost to inspect the ditch, or even repairs to the system. Those are just a few of the examples of costs that can be generated. Now we're getting into more of the detail of what Minnesota law states about ditch redetermination. And it's this statute that really dictates to me as a staff person at Stearns County of how redetermination moves forward. And there's only two ways that a redetermination project can happen. The Drainage Authority may order a redetermination, or there can be a property owner petition that, if the legal threshold is met, dictates in Minnesota law that that redetermination project now must happen. So I think it's really important that we take some time to talk about this term, ditch benefit, which is really a term that's born out of Minnesota legal statutes related to drainage. But when we talk about benefit, we're really referring to how a ditch takes water runoff from another property. And that can be a direct or indirect benefit as this utility takes water from your property. Minnesota law requires that stormwater from ag or non-ag lands to be considered when a redetermination happens. It's this change or conversion of land over time from grassland or trees to a residential subdivision or agricultural or industrial use that's shown to accelerate water runoff. It's the runoff that contributes to the capacity needs of this drainage utility, and that necessitates maintenance or even repairs to the county drainage systems or these water utilities. And so that term benefit is really talking about how your property is contributing water to the drainage system, and it's those viewers that look at how that water moves from one place to another and kind of what that use is, and they assign a cost to it. So let's talk a little bit about what redetermination is and what it means. Redetermination is nothing more than a legal process that updates the drainage system based on present day conditions. In the case of CD28, what that means is that cost share that all the property owners in the system pay for costs with is going to reflect 2022 conditions and uses, not that original redetermination from 1906. Redetermination might be a favorable idea because all the assessments are going to be tied to that 1906 determination, and we know that land use and properties have changed dramatically since then. Now, as a property owner, your first question is going to be, how is this going to affect me? And at this time, there's nothing me or anyone else at Stearns County can share because the process hasn't started. Until those viewers get further down the road with their analysis, we just don't have any information to share right now about how the specific impact to you and your property is going to look. These viewers are going to work independently from the Drainage Authority or from me as staff, and they're going to come back with a recommendation that shows what their analysis results were. A little bit more about these viewers and what viewing means. The viewers must be disinterested, meaning they can't own property in the system that they're viewing, and of course they have to be qualified. The viewing process is actually really closely related to appraising in that they're looking at the impacts of property on a drainage utility and they're assigning an economic benefit to that. And you can imagine how modern technology plays a key role in understanding how water moves from one place to another, especially compared to what was available in terms of a tool set in 1906. Now the viewers are going to prepare a viewer's report, and that's based on state law. And that same state law is also going to detail what that viewer's report must contain. Now, as an example, a benefits and damages statement must show property owners essentially how the viewers did their work. They're going to look at your property and they have to show their work. They have to explain what they saw, what they found, and how they came up with their recommendation. Looking at the specific legal language in Minnesota law regarding redetermination of benefits, there's two components, Section A and Section B. Section A refers to if a drainage authority at its discretion chooses to move forward with a redetermination of benefits. And if those original benefits and damages from 1906 don't reflect reasonable present day values, the Drainage Authority may choose to appoint 3 viewers. Now in Section B, we're referring to what happens and how we proceed if a property owner petition is received, and that's the situation today with County Ditch 28. And as what Section B says, if the Drainage Authority gets a property owner petition, you refer to that paragraph A above that we just went through for how to proceed. Now, the statute appears to show that there's a decision point here for the Drainage Authority, but that's not necessarily the case, and that's because of how the conditions for the decisions are defined in law. So the language in the statute says, in Part B, referring to a petition, it reads that the criteria for deciding on the petition is found in Part A. So we jump back to Part A, which says the criteria for deciding on the petition is based on a review of the original record of benefits and damages compared to reasonable present-day land values, or the benefited or damaged areas have changed. So what it's saying is, have land values changed since 1906? Have the benefited or people that are using the drainage utility changed since 1906? And this is where it gets a little tricky, because of course it would be extremely difficult to make a case that land values haven't changed since 1906. And that's what takes away that practical decision making related to property owner petition from the Drainage Authority. So the result of all this, regardless if it's confusing in law or not, the result is the Drainage Authority is obligated by Minnesota state law to honor the wishes of the petitioners. So when a redetermined project happens, I want to talk a little bit about the timeline of how things generally proceed. So a property owner petition for redetermination of benefits and damages received. That has already happened. At that point, county staff validates the petition. Does the acreage match? Do property owner signatures represent that acreage in accordance with state law? Once a valid petition is presented to the Drainage Authority, then they make a decision about directing staff to find a team of drainage viewers. And again, this is all laid out in Minnesota state law. Once viewers are selected and then appointed at a different County Board of Commissioners meeting, the redetermination of benefits and damages process begins. And what the viewers are going to do, they're going to create a draft viewers report, and that's when the property owners really start to get involved. You're going to get noticed on a series of informational meetings to review the report with the viewers, so you can ask them directly, how they came up with the results they did, what was their analysis, sharing an information that you feel they may have missed that might change how your property is impacted. And again, at this point, once we get into this part of the process, now we're really going to start to understand which of you property owners are going to be affected by the process. Finally, when all the questions, all the meetings are held, we're going to get to a point where there's a notice to you and all the property owners impacted of a public hearing. And that's when the Drainage Authority will consider that final viewer's report and accept that or not accept it. Current status. So at this time, there is no information available about which properties will be affected by a CD28 redetermination process. And I know that's frustrating because that's the number one question everybody wants to know. But that information, that specific property level information, won't be available until the viewers complete a draft of their work. Notification of the petition has been mailed to all property owners who might possibly be impacted. And what that means is we know we overmailed to a boundary most likely larger than will be impacted, but we did that in the interest of transparency. We would rather notify people of what's happening and ultimately have them not be impacted versus miss somebody who will be impacted and they weren't getting notifications of what was happening. Receipt of a notification of the petition meeting does not mean your property will be or will not be affected or part of CD28 ultimately. This slide depicts a map showing this natural watershed boundary, which we modeled our mailing after, and that's that orange kind of shape. The green shaded area around Two Rivers Lake would be the current extent of the system. And again, this is the natural watershed boundary which Mother Nature carved out that sends water to Two Rivers Lake and County Ditch 28 and Two Rivers River. Certainly we don't expect every single property in this boundary to be impacted, but again, we don't know until the viewers do our work. Project summary. The next step required by law is for county staff to present a validated property owner petition for ditch redetermination to the county board who acts as the drainage authority for County Ditch 28. And that's that meeting that's coming up on March 22nd, 2022. Per Minnesota statutes 103E, it is expected that the drainage authority must legally accept the petition and initiate the redetermination of benefits and damages proceedings for County Ditch 28. Costs associated with redetermination proceedings, you're going to have your ditch viewers. Of course, there's legal costs, there's engineering fees. Final viewer costs won't be known until after viewers are appointed. So at this point, really nothing's happened and nothing will happen until that March 22nd date, where we expect the County Board of Commissioners to direct staff to go seek a viewing team, and then prices and costs start to take shape. It's important to remember that damages will be paid to property owners to legally acquire grass buffer strips. And again, that's a point where Stearns County has no discretion. That's written into state law that you must have 16.5 feet on both sides of the actual ditch channel for permanent grass vegetation, and the property owners of that land need to be compensated for that taking. So because of the complex nature of ditch system redetermination, we wanted to provide as much information to you as a property owner as we could. We've set up a County Ditch 28 webpage, which is going to be your best resource for current information. And due to the volume of notifications that were mailed, we wanted to give you as a property owner multiple ways to contact staff with questions or comments. And so there's a web link below to a form where you can submit a question or a comment, which staff can respond to. You can email us directly, or you can certainly call us by phone if that's most comfortable for you. Just please be aware that with the number of calls, staff's going to respond to your phone message as soon as we possibly can. With that, I hope you found this information helpful. I appreciate you sticking with me and listening to this presentation. Please reach out to us with questions and comments, and I thank you again for your time.